Okay, good morning. Today is Friday, May 20th. This is the California Board of Occupational Therapy. We are opening our meeting here at University of St. Augustine in San Marcos, and it is 9:32 in the morning. We're going to call the meeting to order, and I'm going to ask our secretary, Ada Boone-Hurl, to call the roll. We can't hear you, Ada.
My apologies. Thank you. Erin Schweer,
Here.
Vicky Santos,
Here.
Matthew Greco,
Here.
Louis Arabet,
Here.
Ada Boone-Hurl here, Christine Whitlisbach,
Here.
Beata Marcos absent.
Thank you. We have a quorum. All right. Next item on the agenda is President's Remarks. I gave mine yesterday. I have nothing new to report since yesterday, so we will move on to agenda item 15, Board Member Remarks. I'm going to open it up for anyone who has anything they'd like to say. Anything new that happened since yesterday? No? Matthew.
If I could, I'll make one. Thank you. I'm happy to be here and to be able to participate today, and look forward to the work that we do. Thank you.
We are happy to have you. Wasn't the same without you yesterday. So, okay. Public comment for items not on the agenda. If there's any public comment, either here, and we'll also open it up for online comments, please, moderator. We will take those now.
Hi, this is a moderator. If you are a public member who want to make a comment, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're joining us via dial-in, you may press *3 to raise your hand. We'll display instructions shortly, we'll give you a moment. See no raised hands or comments, I return the floor back to you.
Okay, thank you very much. All right, so there were two items that we ran out of time discussing other things yesterday, so we're going to go back to those. Agenda item 11, you'll see that under yesterday's agenda. Discussion and possible action regarding the Occupational Therapy Licensure Compact. And I'm going to turn that over to Mr. Porter, our Executive Officer.
Thank you. As Vice President Willis-Bach mentioned, this was previously agendized for yesterday. We ran out of time to discuss, but this is the discussion of the Occupational Therapy Licensure Compact. This is something that the board has taken a look at before a few number of years ago. And at the time, if you look over the minutes that are included from those meetings in the materials, it was more or less determined that it would not be feasible or likely to pass this through the legislature and get something like this enacted. And that hasn't that hasn't really updated since then. However, we do have a lot of new members on the board. This hasn't been discussed in a while. And so we, wanted to bring this back to the board for discussion for those members who have not had their say on the compact and taken a look at it as part of the board. Following those minutes, there is a list of OT licensure compact member states. This starts off with states that have filed legislation but have not enacted that legislation. There's 6 states. Then there are 28 states that have enacted legislation but are not yet issuing privileges to practice in other compact member states. And then down at the bottom, we have a total of 6 states who have both enacted legislation and have opened their applications for privileges to practice in other compact states. So that's just a snapshot sort of where the rest of the country lies in terms of compact privileges. Moving forward, we do have Occupational Therapy Licensure Compact model legislation. This is quite a long document, and the reason this is included is because in order to join the compact, this legislation must be enacted by the compact state or the prospective compact state in a substantively identical manner. more or less the language cannot change. And that, I believe, in our previous discussions has been the main barrier to pursuing something like this. And again, this is a fairly long document. And then finally, for the materials in this section, we do have a brief description from the compact about how payments are handled for practitioners coming from what they refer to as a home state to practice in another compact state. So these are the materials. It's not really for me to provide an opinion one way or the other, but if the board has any discussion, this would be the time.
Okay. Does anyone have anything they'd like to say, ask, talk about?
As a new board member, however, I have been following this as it's been going through the process, as I know that it would impact. I agreed with the board's previous conversations around this issue related to the fact that I don't know that it would be in the best interest of the California consumers to join this compact, as it would be challenging to monitor, navigate, and doesn't support the culture of practice in California necessarily.
Yeah, it's a tough one because, personally, I would like to see this happen, but I agree with you. And I was in on conversations with the board previously about this, and I don't think it's in the best interest of the consumers. And I don't think that we could realistically get the legislation passed, because my understanding is, and tell me if I'm wrong, that the whole compact language has to be passed word for word. It's like a 50-page document. I just don't think that's realistic. I don't think it would happen.
I don't, from what I was reading recently, and I'm new to this topic, but they mentioned that it doesn't necessarily have to be word for word, but
Okay.
substantively the same.
Okay.
So, and very minor edits may be permissible, but
Right.
the more of those that get added, the more you jeopardize them actually letting you participate in the compact after that legislation passes.
I think it would be a tough go here, and for good reason. And I just, as a licensing board member, don't think it's in the best interest of consumers here. Any other board members want to weigh in on this, Matthew?
Legal, if I may.
Well,
Oh yeah, Helen first.
We have Member Greco who would like to speak. Member Greco, yesterday it was announced that our screen is actually behind them, so they can't see us. So you'll have to
Gotcha.
shout out when you got something to say.
Okay, thank you. So since this was put on for purposes of education, perhaps someone, and I recognize there's 5 of us here who are new, although, could somebody explain who the driving force is? Why are we even considering this? I mean, I understand there is a general argument that it makes sense, from an efficiency standpoint. If you're licensed one place, I want to be able to practice a whole bunch of other places. I understand that argument, but coming from a consumer perspective, I don't see how this benefits the consumer at all. And so my first question is, let's pretend I know nothing about this issue, and it's not really pretending. As somebody explained to me, who is the driving force that brought this up? Who thinks this is a good idea? What group, person, entity? And perhaps the vice president could talk about it, because she said she would like to see this pass. And my question is why?
Well, I said as an occupational therapist, I would, just because it'd make it easier to go. But beyond that, there's no other reason. And I'm not sitting here as an occupational therapist. I'm sitting here as a licensing
Understand.
board member. So that's why I made that comment.
So, but then, could someone at least explain who is who is advocating on behalf of what group is advocating? Is
Yes.
there
We can answer that.
an organ? Yeah.
And we're gonna ask Samia to come up too. Samia, why don't you just sit here because no one else is here, and we can talk a little bit about it from the board perspective, like from California perspective, and then Samia may want to say something from the association perspective.
So to answer your question, Matt, about the who, the main organizations that are driving this would be the American Occupational Therapy Association, AOTA. That's the professional association at the national level, and it's a joint effort with the National Board for Certification in Occupational Therapy, which is the board that administers the test that we use for licensure. So those are sort of the big national organizations, and this is a joint effort between them. They're the main proponents behind this. As far as what would be the advantages to California and the consumer, the first one that comes to mind for me would be that I know we've discussed, particularly when it comes to occupational therapy assistants, certain areas of the state that have less access to services, occupational therapy services, particularly more rural Northern California areas. So the main advantage I could think of would just be that making it, I don't want to say easier, but maybe more accessible for practitioners to come to California might serve to alleviate that issue somewhat. And that's, does any other board members have anything to say, or do you want to turn it over to Samia?
And just so I'm clear, that group that you're talking about, the northern portion, percentage wise, we're talking about a part of the population that's maybe 5, 6, 7% of our population. Are there any statistics that bear out, that there is a deficit in those areas? Are there statistics that talk about how many, is there any sense that people can't do the licensing in California? I mean, I understand it's easier, but maybe somebody could speak to that.
I can
There
tell
is
Ada has something.
significant, oh, I'm sorry.
Oh no, I was giving you the floor, Ada.
Thank you. There is significant data that shows a tremendous lack of access to not only OT services, but a breadth of medical services in rural portions of California. It's for some a healthcare crisis. And so that is captured through the state in a wide, expansive data monitoring for healthcare services in California. So there has recently been from the state a new rural health initiative in an attempt to creatively try to solve the problem, because through traditional practice models, the problem is not getting solved. So we could, there certainly is data to support this need for a significant portion of California consumers. I do have a couple of other comments about what I was going to say, but Matthew, did that address the concern?
Yes,
Now?
that helps for me to understand sort of what the genesis of this was, and I know we also have Sammy who might be able to speak to this issue as well. So,
Right.
but yes, thank you.
Certainly. Just a couple of comments that I wanted to add is I was quite surprised when I pulled this paper out from our materials, in that the last time I had attended a meeting where the compact was presented, there was much more white space than type. So while yesterday's conversation alone on the 8 of 10 and monitoring and all of that for advanced practices, right there is our justification for not getting involved. And even though the background check portion has been, resolved, I, I would like to express interest in keeping a pulse on this and periodic revisiting, partly just to be aware on a national level what's happening, in rather than just setting it to the side. I guess what is my rationale for that is, I to I think all practitioners should be aware of current practice, and so we should follow them in that process of being aware of what's going across California and national practice. Thank you.
Okay, Sammy, would you like to speak to this
Yeah.
issue?
Yeah, thank you. I do believe that Chuck Wilmarth and Kristen Neville were on the call yesterday thinking that this was going to be a topic addressed because they're so invested in this from AOTA. I don't know if they're here today. Can you see that if they're either one of them are here?
Kristen Neville is.
Okay, she might want to chime in. But with respect, when you go to comments for the public online, but with respect to the state association, our members do ask about it. And we've discussed it with our lobbyists at Capital Advocacy pretty extensively at some points in my tenure in this role. And the response is always, it'll never fly in California. Like there's, so many other professionals and professions have tried to do it, and it just gets denied. And so we don't want to pour money into something we know won't work. Even though members do ask about it, our response is mostly, this profession has tried it, this profession has tried it, and it just doesn't pass. So we just we don't prioritize it anymore, sadly, because we don't see it moving through the legislation in the state. But I would love to defer to Kristen if she has anything more to add from AOTA.
Yes, moderator, if you could please open up for online comments, and we'll see if anyone from AOTA or anyone else wants to talk about this.
Hi, this is the moderator. If you would like to comment, please click on the raise hand icon, and Kristen did raise her hand. You're gonna see an unmute request on your screen. Kristen, can you please click on that to make your comment? Thank you.
Hi, good morning, everyone. It's Kristen Neville from AOTA, and thank you very much for the opportunity to comment on this. And Sammy is correct. I do have some input to share. First of all, before I respond to some of the comments that were just made, I have a little update in terms of the information that was in your packet about where the various states that are in the compact are. We have a 7th state that just launched and issued compact privileges this week. That's Tennessee. So I see in the paper in your packet, it says there's just 6. We had the 7th launch on Wednesday. And then in terms of states that have enacted compact legislation, I see Oklahoma and Kansas are on your list. Those are the most recent. But where the legislation in Alaska just passed this past week, so we are waiting to see if the governor in that state will sign that bill. We may very well have a 35th state joining the compact, depending on what the governor does there. So that being said, I guess I would say this is an effort, as Mr. Porter said, that AOTA and NBCOT have both been collaborating on for a number of years. And where it originated from on the AOTA side, it predates my tenure with AOTA a little bit. But from what I do know, AOTA, our board of directors was, our members came to us years ago and identified, what's the word for it now? I'm forgetting. It's Friday. This is what happens. Licensure portability as a concern, such as meaning their ability to get a license in one state and then move to another state and get a license there. So they tasked our board of directors with coming up with a policy proposal or strategy for addressing that concern. And the main solution that came to their attention that we found was a licensure compact, because I believe at that point, that was maybe the early 2010s or mid 2010s. The nursing compact had been in effect. I believe the physician compact had been in effect. So we started the process around 2018, maybe, of collaborating with NBCOT, as well as an organization called the Council of State Governments, which houses the National Center for Interstate Compacts, and they provide technical expertise and legal counsel to states that are pursuing setting up, or to professions rather, that are setting up compacts. And they have been instrumental in helping us get our compact off the ground. But besides that history, I guess I would say the main reason, in addition to what board member Hurl said about the need for the compact, we do have licensees coming to us, particularly the Department of Defense has been a big supporter of our compact because they realize veterans and members of the military and their spouses move quite a bit, and they need to obtain a license in the state they move to. So that's been a big supporter for the military folks, and also just access to services in some of these rural areas. The more licensees and folks that we can get providing services in the profession, whether it's under a privilege to practice or a license, I think is super important these days. That's been a discussion that's been going on in Congress, is how to expand services into rural areas and underserved areas. And there was one other thing I was going to say, but I forgot, unfortunately. So I'll just leave it there. But I'm here and I'm glad to answer any questions. Chuck is actually the real expert on this. He's been very intimately involved in this from the beginning, but he was unable to be here today. And if you want to continue this discussion at a future meeting, he's certainly glad to join. Or to talk to Mr. Porter or talk to any of the members or do a presentation, whatever you'd like.
Thank you, Kristen. Appreciate your input. Are there any other comments from the public or questions? Samuel?
What is the average time frame for someone to get a license in the state of California if they moved here? And, if we're looking at expedited services, care, accessibility, et cetera, because I know we do have something special for military and military spouses, correct?
We do.
Yeah. And so what is the average wait time for people to get a license?
For military spouses specifically, or just in general?
Anyone, not military, because I know there's a special process for military.
It depends, one, on whether or not they're coming from another state. If they already have another license in another state, that can actually sometimes add a little bit of time because we require the state licensure board to send a verification of licensure to us. So depending on how quickly they can get that submitted to us can impact how quickly we can approve their application. Not considering that, though, if we just assume everything arrives on time, I don't know the average, but at most 30 days. Yeah. So at that 30-day point, the board staff are required to reach out to the applicant and let them know, hey, we got all your documents, your application for licensure is approved, or hey, we reviewed everything you sent in and we're missing XYZ document, which for out-of-state applicants tends to be those verifications.
It seems like, though, and correct me if I'm wrong, but you've reported in the past, I believe, that once everything is in, we're pretty fast getting those licenses issued.
So once everything is in, it's very quick. So there's always that initial 30 days. It's very rare that anyone gets approved in a time frame that's significantly less than 30 days. However, if at that 30-day point we reach out and say, hey, you're missing this document and this document, then as soon as we get those documents, we're able to approve same day or next day. It's not like a whole nother 30 days starts because we know we're just missing these two things. So as soon as we get them, we're able to approve. Oh, yeah. And that is another thing that is worth mentioning. If an applicant for licensure in California has a unrestricted license that's in good standing in another state, they are able to practice for up to 60 days under direction of a California licensed OT from the day that their application has been submitted to the board.
Okay. Yeah, thank you for sharing that. I did not realize. Okay, great. Thank you.
That is, if anyone's interested in the law behind that, it's in the Practice Act. It's 2570.4. I believe it's subsection D.
That on the tip of his tongue there.
That one comes up from time to time.
Any other discussion we want to have on this today? Any other comments? Well, I want to thank particularly Kristen Neville from AOTA for being here. I know it was a holdover and you had to come back today for this, but we do appreciate it. We do, and I agree with Ada. I think we need to keep our finger on the pulse of this. So yes, thank you so much for being here and for talking to us about this. We think it's important. It's just probably at this point not going to happen here in California. All right, we're going to move on then. Agenda item number 12, you'll see it on yesterday's agenda. Discussion and possible action regarding seeking an exemption from the independent contractor ABC test, Labor Code Section 2775B under Labor Code Section 2783. Mr. Porter?
Thank you. We're going to talk about our sunset report and our sunset bill a little bit more in depth in the next agenda item, but this is something that the legislature has asked us about in previous sunset reports. For anyone who's not familiar, there was a ruling by the Superior Court of California, I believe it was in 2018, that defined some new standards for how companies and employers classify people as either an independent contractor or as an employee. And the legislature wanted to know from the board if that had any adverse or unseen impacts on the occupational therapy profession, and whether or not it would be beneficial to seek an exemption from that new standards of classification. The board actually did discuss this, I believe, back in 2025, towards the end of the year, and determined that they would still be interested in pursuing that exemption. However, language was never presented to the board, so there was never an opportunity to put forth language for a bill. So in the materials here, there's a lot of information about Labor Code Section 2783, which is the code section that provides for those exemptions. And let's see here. It's the very last document in this agenda item. There's proposed amendments to Labor Code Section 2783. And that has in subsection B a list of professions that are exempted from those new classification standards. If the board is still interested in pursuing such an exemption, this is what the language could look like. It's fairly simple. It's just adding occupational therapy practitioner to the list of exempted professions. But before we proceed, before staff proceeds with pursuing a bill, just want to check in with the board one last time if this language is something they'd be interested in pursuing.
So just want to bring a couple of real life examples to the table just for discussion's sake. And this is what I'm thinking when I hear this language and when I think about this issue, I think about home health practitioners who it comes down to, are you an employee or are you going to get a 1099? Are you an independent contractor? And I think that's, I don't do home health myself, but I've heard my colleagues talk a lot about this. Some people are very strong. They want to be independent contractors. They want to get that 1099 and get a lot of write-offs and things like that for that. Other people, they want to be employees. And there's I hear a lot of back and forth discussion about this. So I'm not sure if the association is hearing a lot of discussion about this and what you can add to that. I don't know if there are I'm sure there are other real life instances that maybe examples you can talk about where this comes up. But before we open it up to OTAC to talk to us about that a little bit, are there any other board members who can speak to this right now? Ada, do you have anything that you hear out there?
In some meetings, I have heard that it creates a barrier for work opportunities for OTs, which thereby prevents access for the consumer. I defer to Samia, though. I think she would have a greater level of example.
Okay. Well, let's hear what Sammy has to say, and then maybe we can have some more discussion about this.
Thank you very much. We have heard from our members, and you're right, Christine, that a lot of people working in home health are very concerned about it. And it sounds like it is a barrier in that setting. And a lot of OT practitioners that work in school districts are also impacted. And when we had our advocacy day in March in Sacramento, when OTAC had its advocacy day in March, this was something we talked about actually as one of our priorities, because we were so excited that CBOT had it in the sunset bill, and that we supported that, seeking out this exemption. And we think that that's a great idea. And some of the examples that were given by practitioners who were at our advocacy day included school-based OT, which I didn't think about either. But one OT practitioner said, you know, it's like I'm a working mom and I have children and I have childcare. And if I can only do 16 hours that week and those schools need 16 hours of evals or interventions, it works for me. So that's not even part-time. It's less than that, but it works for me. And then I could bill for each hour of service. So it provides a lot of flexibility for clinicians who do this kind of work, contract work. And there's a lot of confusion actually about it. And they seek out clarification from OTAC. And all we can do is reiterate what we know, which is whatever's posted. And this was meant to be for Uber and Lyft drivers. And then all of a sudden it spiraled into healthcare providers. And then there are some professions that have exemptions, but we're not one of them. And then we have some OTAC members that say, well, we just fly under the radar and we still do it and hope we don't get caught. And we're like, that's not a good idea. So, you know, OTAC would stand behind and strongly support an exemption of occupational therapy to, you know, proceed with that, and would support that effort in any way that we could.
So from a consumer standpoint, it would open up perhaps more access. It would open up because more OTs might be interested in doing this type of work if they could have that flexibility.
That's right.
OTs hearing.
That's right. OTs and OTAs. It would provide access for a lot of different services, and it would cover cover outpatient, home health, school-based. It crosses so many different niche areas of OT. Yeah.
Okay. Matt, do you have any?
I did have one just general question. I don't know if anybody knows, but what percentage of OTs are employees versus 1099s? I mean, how large is that? Again, how big is this area? And OTAs as well. Is there a large population that is 1099 that would prefer to work 1099? And I appreciate the anecdotal, that anecdotal story, but as a general proposition, most people prefer being an employee over a 1099. And so if we have right now, the system that we have is, in order to be a 1099, you have to seek that out. So what percentage of people are seeking that out?
Well, Sammy and I just look at each other and we both are like, we don't know if there's any, we don't know the numbers, Matt, but anecdotally, and you may or may not be interested in this, but I will tell you, home health and school-based setting is not my area of practice. I don't know about school-based, but home health wise, I mean, I know maybe 10 OTs just, and that's not even my area of practice. My hospital doesn't even engage in it, just in my community who are doing it and like it and want it. And I think, and this is my own thought, maybe because we're so heavily female based and females have children to take care of, I think maybe that might be one reason why it's the 1099 work is so attractive to our profession. I'm not sure. I think Louis might have something to add.
Louis Arbit. So I did home health in the past and I'm an independent contractor. But my concern about this is, as an independent contractor, you need to have your own liability to protect the consumer as well. So I don't know the percentage of how many of these independent contractors who want to pursue this kind of work would buy insurance for their own liability just to protect the public. So if you're an independent contractor, I think it should be mandated to have insurance?
I've worked as an independent contractor in early interventions in schools, in home health, all of the above. And typically it's not even just employee versus. A lot of people do both, right? So if you're one agency, staffing agencies, for example, that do contracts with regional center or things like that, may just in order to piece together services for people, it's easier for them to manage a group of 1099 versus employees, and you're not, providing benefits and those types of things, and you piece it together. It is required. I know in the county requires when you're submitting for your license, they require demonstration of insurance and things like that. And there's great services. It's really not that. I wouldn't say that the need to have your own independent liability insurance would not be a barrier to this for an OT.
It's very inexpensive.
Very. And I think that there are a lot of OTs that would want to practice in this way, and it would increase opportunities for the consumer to receive services.
And that made me think of one more thing too. I know a lot of OTs and OTAs who have a full-time job who have additional work, who do 1099 work, and that increases opportunities
It's a
for
both
them as
and.
well.
So the stats are going to be skewed
Yeah.
if we're
Agreed.
looking at employee versus.
Right. Agreed. Yes.
I was
Like-
in a meeting once, I don't recall the details, but I do remember the story where there was a presenter of a non-traditional practice out of state in Nevada or something, and they were able to have access people in a non-traditional or underserved way. These are fragmented memories, but that they were unable to transfer that model to California for consumers because of needing to use independent contractors because they weren't an employer, more of a facilitator of access. I wish I could remember more details.
Thanks. Yes, Mr. Porter.
If I could add something. So, as the law stands right now, occupational therapy practitioners are subject to what's referred to in Labor Code Section 2775 as the Dynamex or ABC test. And this is a fairly strict set of rules for determining who is or is not an independent contractor versus an employee. Essentially, there are three conditions, A, B, and C. And unless all three of these conditions are satisfied, that person shall be considered an employee rather than an independent contractor. If an exemption were sought and successfully granted for the occupational therapy profession, then that determination would be made by something that's referred to as the Borello test, which is the next item in the materials after AB 2775. And this is a much less strict and maybe more interpretive set of guidelines for determining whether somebody is an employee or an independent contractor. So by seeking this exemption, it does not necessarily mean that now all of a sudden all of these occupational therapy practitioners that were perfectly happy being considered employees are now going to be forced into being considered independent contractors. It's a much more interpretive test. I think it gives employers and employees or independent contractors a little bit more leeway in sort of making that determination for themselves. That just might be something to consider, that it's a little bit more interpretive and all-encompassing, whereas the current set of standards for the ABC test are very strict. Unless all three of these conditions are met, you are an employee.
So where are we on this? Are we in support of seeking an exemption? Where are we?
I'm in support of an exemption.
I would also support, I don't want to limit access to families that need to obtain service.
Well,
Ada, you're.
the only thing, oh,
Yeah, Matt, go
yeah,
ahead.
the only thing that I've heard is that this is appealing to people that are single parents, men or women, that there's an appeal. I haven't heard that appeal or that anybody is having, that there's a barrier. I mean, we have these two strict tests, and if there's a uh, uh, a need that's out there, an employer that like the regional center that wants to use, they're able to do that. I mean, there's nothing that is preventing someone from hiring an independent contractor. I don't see what problem this is solving, because all of the examples, what we've talked about is that people like the ability to have a independent contractor. This doesn't solve that problem. It doesn't make independent contracting legal. It already is legal. The only thing this does is it changes the protections that occupational therapists and occupational therapist assistants have right now, and redefining their position. It gives their employers options and to look at, well, which, do we, if they go into this exemption, then from a standpoint of those occupational therapists, it gives more power to employers. I don't see that as being particularly positive for consumers. So, I mean, at this point, I can't see a reason to vote for this. I still haven't heard a need. What I've heard is it's useful to be an independent contractor. I haven't heard that people are being prevented from being independent contractors. I haven't heard that the more strict definition is preventing people from either employers or people in this field from doing it. So I am still really confused as to why do we, what is the need to amend this? I mean, I still don't see it. I've heard anecdotes that it's people like being independent contractors. I haven't heard anecdotes that there's a need for this bill.
Happy to share further. So yeah, it is.
Okay.
It is part of the, OTs do like to work in this way because it does provide an opportunity for supplemental working, things like that beyond, and the flexibility maybe. But what we've seen as a challenge in practice since this is that employers are reticent to employ independent contractors because it creates much more of a challenge between agencies that are able to provide employees, right, that are able to employ occupational therapists as full-time employees, and the variance of practice need. So we see a fluctuation in service need in a lot of these specialized and niche areas of practice, early intervention, home health, those types of things. There's a fluctuation in service need and in reimbursement and in those types of things. So frequently employers or practice areas, so private clinics, things like that, don't have enough caseload to employ a full-time OT. And so they won't employ full-time OTs, or they would employ part-time OTs, and OTs would not be employed at all. Whereas if they have the capability of hiring independent contractors, they can roll within these fluctuations of service need and in fact offer more service to clients because they have that flexibility. They don't need to wait they get an influx of referrals, they get an influx of client needs, and now they're going through the hiring process because they don't have just a group of OTs on staff. So in order to meet the demand of service needs and the way that third-party payers are paying for services or contracting services, or the way that services are referred in these areas, in order to meet that fluctuation of need within the communities, having independent contracting capabilities allows for us as an OT practice and as practitioners to provide those needs, provide those services as needed, as it comes up, without having the barrier of needing to maintain a full-time OT on your staff and having to then deny the ability to provide services to families, to people who are in need, because you don't have that, forgive me, bench strength to pull from.
But don't they have that ability already? I mean, what is preventing them from using 1099s at this point? Is it just that really they would be using them in a capacity like an employee, where they wouldn't have control over their own schedule, where they would be doing a that they truly aren't an independent contractor. And so what you're saying is we have organizations that are just not providing any services because they believe they would be using them like an employee. I mean, that doesn't seem to address it at all. I mean, it's what you said is there's a problem on the employee side or on the employer side that they don't want to use the 1099, not that they can't use the 1099 that we currently have.
I think the option is that the issue is that they don't have the option. According to this ABC test, it's Labor Code Section 2775. I think that's where the issue is arising from, is that unless the person they are hiring is, as it says here, free from the control and direction of the hiring entity in connection with the performance of the work, performs work that is outside the usual course of the hiring entity's business, and the person is customarily engaged in an independently established trade, occupation, or business, then they can't hire them as a 1099. They have to hire them as an employee under a W-2. I believe that is the concern that's preventing them from being able. They don't no longer have the flexibility or freedom to make that decision whether to hire somebody under a 1099 because we have not sought this exemption. But if that's not hitting the nail on the head.
No, that is hitting the nail on the head.
Because they cannot provide the services. They can't have they cannot hire people under a 1099 because they're providing the same service that they would as an employer.
It's this criteria that we need to get exempted from, or they would need to get exempted from. Does that make sense, Matt?
It does. I rely upon you all as the practitioners to educate me about what the real need is. I don't have a good, and I'll admit it, I don't have a good sense as to what a business would do. So I'm asking it from these questions from a position of ignorance or curiosity. Both.
Yes, I maybe I can shed some light unless I'm interpreting it incorrectly, but we're looking to get an exemption for OTs so that we are not classified as an employee to an employer, right? Without having to pass this test. Because there could be instances where I'm an independent contractor and I have to follow, let's just say, the regional center's instructions, then I could be then considered an employee, right?
You would have to be.
So we would
So-
like to be exempt because then we're all going to be lump sum like they did with the Uber drivers and all of that. And it would limit the access that we can then provide to families
Correct.
for services.
So for example, if you are a vendor of the regional center, okay, and you have 3 OTs on staff, you cannot hire currently under this, you can't hire additional independent contractors to cover an influx of service needs because they would not provide any service different than your employees. So typically with the fluctuation in service as it goes, you could have you could have 2 full-time OTs, 3 full-time OTs, but then a whole bunch of other independent contractors that provide service in addition as needed in order to increase access. If we weren't, but under this regulation, we cannot hire independent contractor OTs because they would not be providing any service different than our full-time OTs.
That's perfect. Thank you, Erin. So, public comment on this issue? Let's open it up. I can't remember if we've officially opened it up, moderator, but if not, let's do it again.
Hi, this is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are a dial-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I turn the floor back to you.
Okay, so it seems like everyone's in agreement that we're still in support as a board of trying to seek exemption for this. Okay, so we would need a motion to direct staff to seek an author to, I don't know, I'm going to have Mr. Porter helps with.
To direct staff to seek an author to enact the amendments in the materials to Labor Code Section 2783. And that it's really just one amendment. It's right there underlined in the materials, adding or occupational therapy practitioner to subsection B of 2783.
This
I
is
know you
legal, if
don't.
I may.
Yes.
So I understand the legislature is asking for sunset. Is this something that could also just be attempted during sunset, or do we need a special bill? We may want to move for staff to seek to initiate legislation and then go whichever way works best.
I'll defer to your judgment if you think that might be a better idea. I was hesitant to maybe lump in other sections of the code with our sunset bill just because it's already gone through. We'll get to this in the further agenda items, but it's already gone through the assembly committees and is ready to go to the whole floor of the assembly. So seeking further amendments to the bill may delay that process. But this is my
Yeah,
first
since they
sunset.
were specifically asking, they're probably already kind of primed for it, but at least that would provide some flexibility if they did wish to include it in the sunset, if the motion was to initiate legislation.
Would a more general motion using the phrase initiate legislation maybe encompass all that?
Yeah, that's what I was talking about, as
Okay.
opposed to seek an author. If it can go into the sunset, we are still in compliance by saying seeking legislation change.
Excellent.
Okay, so I know you've asked us to be more specific for purpose of typing up minutes on our motion. So can you help us be very specific about this motion?
I would recommend to make sure we're covering all our bases, as Helen indicated, direct staff to seek legislation to enact the changes as presented in the materials to Labor Code Section 2783.
And since you've stated, I'm sure you're okay with us saying so moved. Someone
That
do
is
it
fine with me.
just this time. Okay, because we're not going to normally do that. Okay.
Okay.
So moved.
Thank you.
Second.
Aaron has made a motion. Is there a second?
I second. Oh,
Was that Matt?
Ada.
Ada.
Oh, Ada. Okay. Ada seconds. Okay. Is there any more discussion? Open it up for public further discussion if we need that. We do need that. Okay.
Hi, this is a moderator. If you would like to make a comment on this motion, you may look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. See no comments, I turn the floor back to you.
Okay, Ada, call the vote, please.
Ern Schweer,
Yes.
Vicky Santos,
Yes.
Matthew Greco,
Yes.
Louis Arabit,
Yes.
Ada Boone Hurl, yes. Christine Whitlisbach,
Yes.
Beata Marcos, absent.
Motion passes. Thank you so much for the great discussion. Thank you, Aaron, for finally making it understandable for everyone. I appreciate that. All right, moving on to agenda item 17. Discussion and overview of the board's jurisdiction and authority, legislative and regulatory action. Mr. Porter.
Thank you. Before I get started on this, there's just one document in the materials here, overview of the board's duty and authority to protect the public. This is something that I worked on in conjunction with the board counsel, with legal counsel Helen Joffroy. So if at any point, Helen, if you have anything to add to what I'm saying, feel free to jump in, or if you have anything at the end. But this is just sort of a summary of the board's duty and maybe what their responsibility and ability to seek legislation or changes to code sections is. I'm not going to read the whole thing because it's right in front of you. If you need to read it, it's there for you. But what this talks about is that the existence of a licensed profession creates this relationship between consumers and the professional that is imbalanced in favor of the professional in terms of giving more power to the professional. Because a consumer must rely on that licensed professional's knowledge and expertise in their field. So there is a imbalanced relationship there that necessitates a degree of trust between the consumer and the licensed professional. And in order to sort of shift that balance back in favor, or rather towards the middle, to make it more balanced than imbalanced, licensure boards are created to create rules and seek legislation that protect consumers from bad actors amongst that group of licensed professionals. It goes on to state that actions of the board that it asserts are for the protection of the public, but may really be seen as for the benefit of licensees and the profession can be overturned. There's an example in here about a North Carolina Board of Dental Examiners case where professional members on the board sought legislative changes that would prohibit unlicensed professionals from performing teeth whitening services, and those licensed professionals that were on that board also offered those teeth whitening services. And it was determined later that what they did is they sent cease and desist letters out to those unlicensed individuals, and eventually this went up to the Supreme Court in the state, and they overturned those that decision that the board had made. So it's just something to keep in mind that, and we talk about this all the time, but that the board's decisions and legislative changes and regulatory changes that it seeks should really be coming from that place of seeking to provide protection for consumers rather than advancing the profession. Of course, it's not that we don't want the profession to be advanced, but that we have professional associations who are there for the profession. And really what this comes down to is the expectation of the legislature. The legislature does not typically expect the board to submit legislation that, or the legislature does expect the board to submit proposed legislation that clearly supports the public health, safety, and welfare, or the board's ability to carry out its duties. And if the board submits such legislation, the associations are free to support, oppose, or remain neutral, and vice versa. The legislature expects legislation that furthers or expands practice of occupational therapy or benefits licensees to be coming from the associations, and the board can likewise oppose, support, or be neutral to that legislation. This is brought up at this point in the agenda just because it has relevance to the following agenda item, but we wanted to provide this information to the board, especially because we have some new members. And Helen, if you have anything to add, by all means, or we can go to questions and comments.
I don't think I have anything to add, but I'm certainly happy to answer any question.
Board members, are there any comments, questions, concerns, confusion?
One question is this a document that would be posted on our website and available as an item for the public?
It's available in the materials for this meeting, but it could be posted elsewhere on the website, maybe a little more front and center if that's desired.
I think it would be a nice statement to have that basically saying that our role and our mission is to protect the consumer, and it's an educational piece for the public.
Matt, did you have a comment? I thought I saw you do some. Okay. We're going to open it up.
No, but thank you.
Thanks.
No.
I can see you in front of us a little bit, but you're kind of tiny. But yeah, sometimes I see you flinch and think maybe you have a question. All right, so we're going to open this up to public comment, both in person here and online. If the moderator will please do that.
This is the moderator. If you would like to make a comment, you may look for the raise hand icon at the bottom of your WebEx screen. And if you are joining us by calling in, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no raised hands. I turn the floor back to you.
Okay, I'm just going to thank you so much. Tamia?
Should this carry over into the next item, or
It's a guide for
It's a
when we
guide.
discuss the next item.
appreciate it? So, okay, one question as I'm reviewing this document again about the dental hygiene and teeth whitening. This is fascinating to me because the dental hygienist cleans my teeth, but sometimes the dentist does. And I'm like, why does the dentist want to do it? So, and then I'm like, is this about billing? Is it because the dentist gets paid more and can bill for the teeth cleaning versus the hygienist? I don't know. I'm going to ask my dentist when my next appointment. But what if cleaning the teeth was in the Practice Act for the dentist? Would it be a different story then?
I think in this particular example, this is a little bit outside of how our board normally operates, but rather than seeking legislation to add this to the Practice Act, they sent cease and desist letters to the people that were offering these services. And I don't think it was in their Practice Act that teeth whitening services are the exclusive domain of dental examiners. So they sort of were seeking to, in a backdoor sort of way, claim that without having it added, it wasn't in their Practice Act, and then they sent these letters to people to not do that.
And it got overturned.
Mm-hmm.
But what if cleaning? What if teeth cleaning was in their Practice Act? Would it be a different story?
Would the board like me to add
Yes,
anything?
please. Yes.
Yes, so that was kind of the point. That was one of the points, is that it wasn't in there defined by the legislature who has the power to essentially create the board and their responsibility to the public. If the association had moved to include it in the Practice Act, then yes, it would have been limited strictly to dental professionals, and the unlicensed persons couldn't act. But in that it was not in the nor was there any indication that there was a need to put it in there. There was no public safety issue. The board was in error by enforcing it as something only a dental professional could perform. So that would be kind of the point, is the board itself could not add in there, because that would only expand unless there was a clear danger to the public in allowing non-licensed professionals to do it. Then the board could move saying, we have this tragedy going on in the public. People are getting too white in their teeth, or whatever the deal is, or burning their teeth. But in that there was no safety concern, the board would be basically acted without moving through the legislature and moved to further its own licensees as opposed to the public. So yes, it would have been different had it been in the Practice Act. It would have been defined as a professional's duty.
But I think maybe one important thing and you did kind of mention this, would be that even if they had decided to seek legislation to amend the Practice Act to put it in there, it would have been likely to have failed because there was no, in this particular instance, public
Correct.
safety concern identified.
Got it. Okay,
Correct.
that's
if
very
there was
helpful.
a serious, oh, sorry.
I was just saying that's a helpful example. Thank you.
Yes. So yeah, if there is, the board is welcome to solve a public safe problem, but it would have to demonstrate that non-professionals are harming the public in doing teeth whitening. And of course that has happened before, where, you know, there's a activity and so it needs to be licensed. And so it's added either to a practice act for someone, or an entire board or bureau is created in order to create enforcement for that particular activity. So, but if there is no public safety danger, the board cannot move, because there would be no benefit except to the licensees, and that is not their duties.
This is great information, and I know that this has come up before, and we've talked about it before. I don't want to say just in passing, because it hasn't been in passing, but we haven't really seen it in black and white just this way. And I so appreciate it being put in black and white, so we can refer back to, and maybe even just hold on to this. It may go into future agenda items, because things like this come up all the time for different things. You know what I'm talking about.
Yeah.
So thank you so much to Austin and Helen for bringing this to us in this way, to make it very clear. It's helpful. It's very helpful, and we appreciate that. Is there any more discussion on just this agenda item 17? Are we ready to go on to agenda item 18? Okay. Okay, so let's do that. Moving on to
Public comment first, please.
Yes, please.
From the online.
Mm-hmm. Oh, yes. Let's open it up for online comment, is what she's saying. Thank you.
Hi, this is a moderator. If you would like to make a comment on this agenda item, please click on the raise hand icon at the bottom of your WebEx screen. We'll be displaying instructions and we'll give you a moment. See no comments, I return the floor back to you.
Okay, thank you very much. Great discussion. We'll keep that in mind as we move on to agenda item 18, discussion and possible action regarding sensory integration interventions. Mr. Porter.
Well, the first thing in this agenda item is the letter from OTAC seeking clarification from the board regarding sensory integrations and intervention. And since we have OTAC here, maybe we'll just let them speak as to what their letter is asking about.
Thank you. Appreciate it so much. And thanks for putting this on the agenda. So on behalf of OTAC, because I have Vice President Kirsten Laughlin here with me, we wanted to briefly summarize the concerns we submitted in our letter regarding sensory integration, sensory processing interventions, and occupational therapy scope of practice. In preparation for today's discussion, OTAC did conduct a brief survey of occupational therapy practitioners across California, and the responses revealed several consistent themes. If I can just review those with you. So first, practitioners are increasingly observing non-occupational therapy personnel providing sensory-based interventions. The providers most frequently identified included board-certified behavior analysts, or BCBAs, registered behavioral technicians, or RBTCs, applied behavior analysis providers, or ABA providers, speech language pathologists, early interventionists, aides, and other paraprofessionals. Several respondents specifically reported that sensory interventions, sensory diets, feeding interventions, activities of daily living, or ADLs, and visual motor interventions are being implemented by individuals without occupational therapy training or oversight and supervision. Second, respondents expressed significant concerns regarding safety and clinical appropriateness. Practitioners described examples like misuse of weighted utensils or weighted tools, inappropriate sensory diets, sensory tools being used behaviorally rather than therapeutically, feeding interventions delivered without specialized training in feeding, and services being labeled as sensory integration by individuals without sensory integration training. Multiple respondents stated that these practices may create consumer confusion and potentially place children and their families at risk. Third, respondents reported that occupational therapy services are in some cases being reduced or replaced. One school-based practitioner described occupational therapy positions being reduced, while applied behavior analyst providers, registered behavior technicians, and other providers were expected to, quote, fill the gaps. Many respondents expressed concern that occupational therapy services are increasingly viewed as interchangeable despite the specialized education and clinical reasoning required for pediatric OT, sensory integration, feeding, activities of daily living, and occupation-based intervention. Fourth, respondents emphasize that interdisciplinary collaboration itself is not the concern. In fact, many practitioners strongly supported collaboration when occupational therapy practitioners provide evaluation, formalized assessment, clinical reasoning, treatment planning, and oversight. The concern arises when occupational therapy specific interventions are implemented independently without occupational therapy involvement, training, or supervision. Finally, respondents overwhelmingly requested clearer guidance and stronger recognition of occupational therapy's scope of practice. Themes included clear recognition of sensory integration and sensory processing within occupational therapy practice, stronger consumer protection language, support for practitioners encountering scope encroachment, and clarification regarding when these services may constitute unlicensed practice. And I think that's at the heart of it. It's like, when are other people doing these services acting like occupational therapists without a license? Overall, the survey findings strongly support OTAC's request for board consideration of the questions listed in the letter. So the first one being whether the provision of sensory integration intervention, when delivered in a manner consistent with occupational therapy practice, falls under the definition of occupational therapy as outlined in our practice, because it's not in the Practice Act. How the board determines when the provision of sensory integration interventions crosses into the unlicensed practice of OT, whether the board has concerns from a consumer protection standpoint regarding the provision of these interventions by individuals without appropriate training or qualifications, and whether additional clarification, whether it's through policy, guidance, or future regulatory consideration, may be warranted to support public protection and reduce confusion. So we certainly know that's a lot. I think the letter, in addition to the responses we received from the survey, really solidified to OTAC that something should be done. We're just not 100% sure what those steps are. Is it the board? Is it the association? Is it legislation? Is it the Practice Act? So it like spiraled, as you can see. So we appreciate the board's willingness to discuss this, a really important issue, and OTAC looks forward to continued collaboration and dialogue.
As do we. Thank you. Thank you for that. I have a question.
Sure.
So when you said, I forget how you said it, so I'm just going to ask my question. It'll become clear. And maybe Erin, you can weigh in on this as well, because this is your practice area. You said something about, when does sensory integration provided by a non-OT, when does sensory integration provided like an OT does it? Something like that. I forget your exact word. And my question is, when someone is providing sensory integration services, how would it look different? Does it look different when an OT does it as opposed to a non-OT? Because I would think, based on my very, very limited knowledge of it, that it would look the same. So what makes it OT?
I would like to defer to Erin on that.
That is a fantastic question.
What a question.
What a question. I think the difference is in the training and in the potential risk to the consumer. So the actual interventions may not look different to somebody from the outside, which is why it's easy for somebody to assume that they're qualified to use this as a therapeutic modality, right? As with all OT, right? A lot of our interventions are people's everyday things, cooking, playing as a kid, things like that. So if we just break it down to one of the primary sensory integration tools, a swing, right? We're not regulating kids swinging on the playground. We're not regulating those types of things. It's when somebody is approaching a client therapeutically and using this to facilitate some therapeutic outcome. So a behavior technician, a BCBA, typically they're using it to modify behavior, and that is an inappropriate use of sensory integration, because sensory integration and sensory processing approaches are a skilled facilitation of regulating and changing nervous system responses to outcome.
I'm not disagreeing with you, but I guess I would say, just being the devil's advocate,
Yeah.
but isn't the ultimate goal, doesn't that mean changing behavior?
Changing participation for OT, not
Okay.
compliance necessarily. So that's where we run into this, where with a
Okay.
BCB, right? So it's changing your ability to participate in what you need to do, not necessarily just compliance. So what we see is and interdisciplinary practice is not the problem. That's not the discussion. So if an OT is on the team and has trained the BCBA and they've worked together to develop intervention strategies and plans, then the BCBA can input it. But can enact it, can follow through with it, as long as it is that interdisciplinary approach. The challenge comes when we are seeing things like, oh, we don't need an OT anymore because we have a behaviorist who's going to do these things. And what I've seen, unfortunately, is the misuse of a lot of these interventions. So, weighted vests, weighted tools, swings, things like that, that actually can harm.
Talk
the
about
kid.
that. Talk
Let
about
me
the
talk
harm.
about that. So if we're talking about a child who has some of the, right, they're referred for behavioral issues, typically is where we see that. But what we see is the nervous system's inability to process the information in their environment. And so what sensory integration approaches and sensory processing approaches do is help them externally, internally provide opportunities to increase that threshold of their processing, the ability for them to participate and process information within their environment so that they can then be more successful in their day. The misuse comes with some of our tools and things like that can either overstimulate the child inadvertently or can create external behaviors and things like that can cause trouble for the child without knowing it. So somebody who's not skilled therapists in looking, assessing, regulating, or watching and intervening could inadvertently set the child's nervous system into a place that's going to increase risk behavior. So frequently these are the kids that are referred for behavioral reasons: fighting, biting, running, those kinds of things. I have unfortunately seen situations where a BCBA untrained has inadvertently, thinking they were doing a good job, put a student into a state of nervous system regulation where they then compulsively ran into a street. And they were unable to regulate that child to return to participation safely. Under skilled observation and evaluation, coming up with an interdisciplinary plan where the BCBA we can train the BCBA to be there on a daily basis. But the BCBA in and of themselves don't have the skilled training to provide that. And it is something that even as an OT, you need to have additional training to provide.
Yes, for sure.
So
do physical therapists provide sensory integration?
Physical therapists can be certified. They are allowed, they can go through the certification processes. Rarely they do.
Do or do not?
They do, they are allowed. I have not seen very many who are actually trained and certified. It's similar to hand therapy in that way, right? So they can be trained.
Yes.
But
yes,
it comes
it's a
from a
crossover.
different.
Yeah. But those, you feel, from what you've seen, you feel like a trained physical therapist who's certified in sensory integration is providing it safely. We're talking about something
They don't
else.
tend to provide the same type of service we do because of the referral process, right? Not really within their scope of practice. When a PT is certified in it, they're not providing sensory integration intervention necessarily. They're using it as a foundational knowledge to support movement and participation in what they do. I have not seen physical therapists providing because of the other scope of practice issues.
Thank you. This is so helpful. I'm just trying to wrap my head around it. I'm just trying to figure out, is sensory integration OT, or is sensory integration something that OTs use?
Both. I would say that sensory integration is something you use.
Okay.
The knowledge and understanding and scope of addressing sensory processing capabilities in a person is our scope and something OTs do. So I would be a proponent.
Only OTs do. Because that's the crux here.
Well, yeah. I mean, I
That's how
can't
you
speak,
feel.
I
That's
can't speak to other people's
Yeah.
scope of practice or, regulation, but it's in looking at what we do as occupational therapists, this is something that it is in the primary scope of what we do. It's in our OT, the OTPF has it outlined, those types of things, that it is something we do. I would be a proponent of making sure that the sensory processing language is in the Practice Act, not sensory integration. Because when I feel like sensory integration, we start opening a whole can of worms for having specific interventions that aren't necessarily right. NDT and all of those things would open into that.
I got you. I see you, Matt, and you're coming right up. Yeah, I just want to make sure that we're not getting into a thing where we're going to start listing treatment modalities.
I don't want to treat exactly. I'm with you. I would not be a proponent of listing sensory integration because it is a treatment modality.
Yeah.
But I do think we need to specify in the Practice Act that this is a domain that we are as OTs are specifically trained in order to help somebody's occupational participation.
And in your opinion, this is or what you have seen, not opinion, what you have seen that this is actually causing harm.
I
when
have seen
untrained
this.
people,
I have
non-OTs.
Yeah.
Okay.
And,
Okay. Gotcha.
board licensing board hat off.
I
have been called into different agencies as a consultant to support training when it has gone awry.
Gotcha. Okay, Matt.
I was just going to thank Board Member Schweier for that explanation. That really helped me. This was another area where I needed a little bit of education and help. And I did a little research on it myself. I saw that this occupational sensory integration intervention was conceived of by a occupational therapist named Dr. Jean Ayers, who appears to be fairly prominent in this particular area. And I'm always mindful of creating barriers that are artificial versus real. And this seems like something that isn't creating a barrier, but is truly it's an issue of it's like that. And there are a lot of fields where, and a person who's watching from the outside could duplicate what they see, 95% of it. But really what we want from the expert is that 5%, that little part that actually understands why all of these other processes are occurring. And it seems like this falls into that 5% category. So I think it makes sense to try and figure out a way to make that clear. And I don't know what the vehicle for that is, but this seems like something that it's worthwhile not to keep other professions from performing the job, but from making it clear that there's specialized knowledge. So it isn't just being able to replicate that 95%, but it's being able to understand the why and the unintended consequences if you don't perform it correctly and so forth. So.
Great. Thank you. Unfortunately, we are going, it's okay. We need to take a break. We have a board member who has a half-hour conflict. It's Erin, and we need her for this discussion. So we're going to take an early lunch. We're going to just do 40 minutes, if that's okay with everyone, because I do intend on wrapping this meeting up early, and so we can all call it a day. But we do need to break early for lunch, if that's okay with everyone, and we can continue to discuss this discussion when we return. Is that okay?
Absolutely. I don't know, because I'm on this side. I can see that Helen had her hand up. I don't know if you saw that.
Helen, do you need to urgently say
I
something?
did. I was going to provide some information, but we can certainly wait until we get back.
Let's do when we get back so that'll be fresh in our minds what you have to say. Okay. Okay, thank you. So we will reconvene at 11:35. Okay, we are back. Thank you everyone for your patience. We were on agenda item, is it 18? Yeah, okay, agenda item 18, and board council was just getting ready to make a few comments about this item. Thank you.
Do
Can
we
go
need to
ahead
take
and,
roll?
I was going to say,
Oh.
and take roll first?
Yes, I guess we'll do that first. Ada, please take roll. Thanks.
Aaron Schweer,
Here.
Key Santos,
Here.
Matthew Greco,
Here.
Louis Herbert,
Here.
Ada Boone Hurl here, Christine Whitlisbach,
Here.
Beata Marcos, absent.
Okay, Helen, please.
Okay. So I just kind of wanted to illustrate, Member Greco was accurate in his assessment in that the goal here for the board is to protect the public, but limiting it just to occupational therapy would be of benefit to the licensees and not necessarily the public. The broadest method of public safety would be, for example, the legislature to place in the 800 series, which applies to all healthcare professionals, that if you would like to perform this service, you have to be certified by a college that is accredited by the Department of Education. And then therefore anyone could assist, would be properly educated and trained. And, you know, any location that did not have access to an occupational therapist could still provide these activities. So if it is indeed something that only an occupational therapist can do or should do, that would be for the association to petition to the legislation. Or if they feel, for example, this is something that OT and PT should do only, then those two associations can work together in order to put it into the proper Practice Act. And alternatively, you know, you can be a lawyer, accountant, social worker, nurse, acupuncturist, as long as you get the licenses. So it may be of such a safety need that they need to create a new license type or anything like that. But in that it starts to grow out bigger than just what is OT and what that then becomes, and there are alternative ways to safeguard the people. That would be a legislature concern that would be best forwarded by whomever felt that they were the proper, or groups of licensees that felt like they were the proper parties in order to do that professionally.
I appreciate that input, Helen. I just have some questions about what you just said because I want to make sure I understand.
Mhm.
So based on agenda item 17, trying to find it again, sorry. I thought I understood that if it was a consumer safety issue, that it would be appropriate for the licensing board to propose legislation. But I'm hearing something a little bit different here. You're saying not in this case, or can you explain why in this case it would not be appropriate?
Yes. So we have to still work within the Practice Act as the legislature gave it to us. So typically we do not expand the practice into anything. We can make it perhaps more detailed, but in order for it to be specifically directed so that only OTs can perform this, the legislature has to give us that authority. And for us to ask would be of benefit mainly to the licensees in law strictly to OTs, as opposed to being able to open it up to whomever has proper education and licensing. And at which point beyond ours, and as we mentioned during the discussion, this can be interdisciplinary, the right word, and PTs could do it, but as you know, but of course we would like them to have the licenses, etc. So it's up to the legislature to either deem which profession or professions are appropriate to have this in order to maximize the safety for the people. For example, respiratory care, I do not know what the service is, but it has something to do with breathing. Respiratory care professionals are the only ones that could perform this treatment. However, traditionally, another profession, I don't know if it's LVN or nurses or somebody else, was also performing this service. So when it finally came down to this will be effective on this date, we actually had lots of people who poured into the respiratory board saying, I don't have someone to help me and my child with breathing because I had this person and now this person can't perform this. And multiple locations had no one of respiratory care licenses to be able to perform this service. But breathing is important. So here, if another disciplinary or another licensee would be appropriate, it's up to the legislature to either assign where that goes, create a new license type, or as the proper education can do that. But all of that is beyond what we would do in enforcing our own practice act. I don't know if that made any more sense to you.
Helen, I have a
Aaron has
question. You referenced the 800 series,
Mhm.
and so that would be select like OTPT or a medical discipline is what I think I interpreted. How then would you
I
go
apologize. I guess it's the 500 series. So the
500?
Business and Professions Code 500 through it has to be through 800 because there's an 800 that does apply to all healthcare professions. They have provisions in there that will apply to all healthcare professions, but for example, do not apply to accountants because it's very specific for healing professions, but it applies to all of them.
And how do you capture the applied behavioral in all those folks? That would be under a
They
separate
are considered healthcare
number.
professions.
Okay,
Yes. So
they would fall in that. Okay, thank you.
there's
I have a follow-up
a
question. If
list
we're,
that's all under the act that specifies.
Thank you so much for that clarification.
my follow-up question, well, I don't know how to phrase this as a question, but I was thinking back to our conversation about the fact that there are two things at play here, and this is one of those confusing pieces, right? We're talking sensory integration practice, sensory integration therapeutic intervention versus sensory processing as part of our practice act. I would see a world where we could enhance our practice act to clearly define that this is more clearly define that this is within our scope of practice, that this is part of our expertise as occupational therapists, sensory processing, because that is part of our general, our knowledge, those types of things. And I could see separating out to what you're saying, whereas sensory integration, which is a treatment modality, that would be more of that. I guess we've now clarified it as a 500 series thing that could be
Yes.
somebody.
Well, and this is where like the line is very fuzzy. We want to protect the public, and nothing says that occupational therapy should not be the only profession that does this. But that decision is one that's vested in the legislature and not us at this time. And for us to expand the scope of practice would be for benefit of the licensee, whereas the legislature may find that multiple boards should be able to perform this service.
I hear what you're
So
saying.
when
I
it's
think the challenge
yeah.
that I'm having is that this doesn't expand the scope of our practice. This doesn't,
in the law. It would.
it would.
Yeah,
Even
in the
if we're
law
just
it would because
clarifying?
it would limit it just to
Really?
OT because that's really all we can regulate, and that means that it would create a law outside of our practice to put it in there, or here's the thing, the legislature would have to put it in. We are not the parties to forward it because it creates there's a for for concerns. But even an accountant can do it as long as they take the courses, then that's for the legislature to either determine only OTs can do it, or OTs and physical therapists, or OTs, physical therapists, and behavioral specialists. We have in our own act, we reference, I know speech therapy, and there's another one because our profession overlaps so much with other professions. I guess it's PT and speech therapy. And so the legislature needs to determine which is best. The association is the one that says OT is best and OT should be the only ones, or OT and PT work together to say just us. We are the only ones who should be able to do this as part of our profession. But monopoly to our licensees for public profession protection. We can support the bill.
I just want to clarify, or ask for clarification rather. So my impression of the situation was that an attempt to add something to OT's scope of practice on the part of the board was going to be more closely examined for the reasoning and motivation behind it to determine whether this was for the benefit of the public or for the benefit of the licensees. But what I'm hearing now is that really any attempt, regardless of the reasoning and motivation or reasoning and motivation behind why, to add something to the OT scope of practice on the part of the board would be seen as for being done for the benefit of the licensee for the profession. There's no determination made on really where the reasoning is.
So the reasoning is this: if it is something, and unfortunately our particular scope of practice is very, very broad, right? So within our scope of practice, if we were the only ones to perform something that was laid out in our scope of practice to do, then this is what we could regulate within our own regulations. The minute we have to go and expand our legislation, or we have to call out something in our legislation, and this is something that it's not currently in our act, so therefore our duty is actually to enforce the act. So an expansion of scope is almost always not us. So
Even if
something in our scope that we can define is a little better. But even during the discussion, we had multiple professions that could potentially do this. We can absolutely support the bill. We can absolutely say that, we totally agree that only OT should be able to do this, or whatever the bill says. But the board has, in the confines of the act that as given, and make that more implemented, clarified, and more specific. But during the conversation, we have multiple professions that can do that. So it's more of, it absolutely has to benefit the public, period. But we only act within our own profession. For example, having only licensed accountant stations is for the public safety, but that's nothing to do with us. So our something to do with us is what we have directly laid out in our statute, and then we can absolutely maximize that however we feel is necessary. But expanding that is basically, for lack of a better way to phrase it, us asking for more power, or us asking for a monopoly for our licensees.
So then how do we bring forward, because we're not trying to completely own it, because our ultimate goal is safety, how then would the next process go in trying to us leading the way towards creating, would it be in that 500 series that only specifically trained practitioners perform select modalities or interventions? And I'm not an expert, so maybe Erin, you get the gist of what I'm trying to ask. How do we do something?
So
Yeah.
in the only method I could see where the board would, quote unquote, lead the way would be to discuss with DCA General, because you do not want board on board argumentation or arguments for who has the proper scope of practice and whatnot. And DCA could then advise on how we get something within the general series in order to protect the public, or to alert the legislature that we have. But the only party that can lead by the OT and only OT, or whichever associations work together, that has to be done by the associations themselves. Because otherwise, like I said, the maximum method in order to protect the public is to make sure whoever does that is trained to do it, no matter who they are.
You cut out just for a minute there. So you said that the only people that should
The
be
only way, the
introducing-
maximum method, I'm sorry, go ahead.
I think what you said is the people who should be introducing any legislation to expand our scope of practice should be the association. Is that what you said or not?
Correct. Correct.
Okay. We're just all thinking and looking at each other.
Well, it seems to me, and this is again a decision for the board to make as a whole, but from what I'm hearing, it seems like the path of least resistance, if something were to be done about this, would be for the association to put forward a bill, and then the board would discuss whether or not they'd like to support that bill. So there's no requirement that the board has to vote on any legislation or desired legislative change today. But I think the discussion has been very helpful in determining how the board feels about the topic as a whole and how it might respond to a bill put forth by the association.
Would it be something would it be within our scope or purpose to have an ad hoc committee to participate in the discussion, or do we have to keep them completely separate in the process?
I think it's probably better to
Within
keep
our
it separate.
practice act, I'm sorry.
Go ahead, Ellen. That's
Within
my
our
opinion.
I'm sorry, go ahead.
I just said it's my opinion. We should keep it separate, but perhaps I'm wrong on that.
Oh, no.
So-
Within our practice act, we have control over the licensees. I can regulate that our licensee receive a certain certification or take a certain class. So we can do that. And nothing stops us from doing that. Or if we feel that as part of their OT training, they already have this knowledge and experience, then we do not need to further confine them. But we cannot say that only OTs are the only ones that can do this. So technically all the other professions could also say, hey, if you're going to perform this, you have to be certified, or, hey, we consider this to be part of your normal training, so you can do it at will. But we can only control licensees, and in that this could easily cross into multiple disciplines. It needs to be done by the associations that wish to do so.
To answer your
Behavioral
question,
therapists
Ada,
could be putting forth a bill right now, and then, I'm sorry?
sorry, I just to respond to Ada's question that she had asked, I think I don't think we need to have an ad hoc committee, was I think the response that we were looking for.
Yes. Well, I think the only thing an ad hoc committee would do is determine whether we need to regulate that our licensees must complete a certain course in order to perform these services.
Right. And I don't think that's the issue in front
Yeah.
of us right now.
Well, that's what I'm saying. That would be the only control that we have.
So then the association brings forth to the legislature that there's a consumer safety concern. That's what I'm hearing?
Yes. So the association has much more flexibility than we do because they are not confined by statute for their duties. So they can actually put forth a bill that says all healthcare professions should be able to do this with, they don't have to advocate strictly for OT, but they can, it's usually within their or you have to have an OT license in order to service, or they work with another association like PT, and the two of them come forward, draft a bill together and say, we two are the only licensees that should be able to do this. But the association can absolutely the association can put forth a bill if they are aware that licensees are harming the public with something they're doing, and they need to lead the way, or they want to lead the way in order to protect safety and protect the integrity of the profession. They can put forth a bill that says licensees should not be able to do X as well as us, or we regulate it that way. So they have maximum flexibility to assert general public safety, specific OT public safety, or OT benefits. OT professionals should not get paid less than $200,000 a year. I doubt that bill will pass, but they are certainly within their powers to pass or to propose whatever legislation they want to. So they are much more flexible.
But my final question, in the scope of consumer protection, though, it potentially could be, from an education and outreach perspective, be appropriate to do a consumer education resource on defining these different aspects of sensory interventions, or something along that line. I mean,
So we can define that within our own practice and what to just OTs. So we can say this is we take this class, that class, and 4 years of experience or whatnot. And no OT that doesn't have that cannot perform that. But we cannot put that in our practice act and therefore prevent physical therapists from doing it, which is what a scope of practice expansion does. It says only us can do that.
And I was just thinking from an education and outreach, like, this is sensory, and we do part of this. And you hear this term, it means that. And you hear this term, it means that. Just really general, basic consumer education of terminology on the subject would be appropriate or not appropriate.
We can probably put that on our website, because it's not saying no one else can do this but us. It's just
Right,
simply
it's
defining
just
the
defining.
modalities. We can also define it in regulation so that it is codified exactly what these two mean.
Thank you so much.
Austin, can I just piggyback off of something Helen said earlier really quickly?
Of course.
When Helen was mentioning other licensee populations that had basically a difference of opinion on who can do certain tasks and services relating to breathing, that does have to do with the Respiratory Care Board. And just anecdotally, this was different, but may help show how this could go, where there were two different types of licensee populations that felt that they were rightfully performing certain kind of breathing tasks and services. It was a decades-long discussion and frankly, difference of opinion that eventually made its way to legislature. And it was the legislature that determined, by changing the scope of practice of one of the licensee populations, who could actually perform certain of these respiratory care services. So on one hand, the legislature changed the scope of practice by adding statutorily, LVNs may not do XYZ. And simultaneously, they directed a different board, the Respiratory Care Board, to input through regulation who and how, what could actually be done when it comes to respiratory care. So even when you're going to the legislative level, it may be that they direct multiple boards to work together to come up with training, education, and various standards under which multiple licensees of various in various professional industries can perform the tasks that we're talking about. So that's just something to keep in back of mind of how something could play out.
Thank you. That was helpful.
Yes, thank you to both our legal counsels for helping us with this. Is there any public comment at this point? Go ahead, moderator, and open it up, please.
Hi, this is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a dial-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I turn the floor back to you, Chair.
Okay, thank you. Samia?
Thank you. Thank you for this discussion. It's very helpful. And we'll have to take this back to the association to figure out if there is capacity for such a bill. I do like the idea that Ada Boone Hurl discussed about potentially educating consumers and having something on the website, having something on the California Board of OT's website. And we did talk about this with our lobbyists and, thought about, yeah, if Kirsten, if you remember this, and we thought about like, what could CBOT do if this is not something that can be, like, if we can't change the wording in our practice act right now. And I agree with Aaron. I don't see it as expansion because it's what we do already, but I understand if you change the language, it's by default expansion. But is there some kind of publicity or some kind of public campaign of educating consumers, whether it be outreach to schools or LAUSD, whatever it is, so to help people understand what it is that occupational therapists do when it comes, occupational therapy practitioners do when it comes to sensory processing intervention? And if that is something that could be done by CBOT, whether it's a campaign, letter writing, or outreach to schools, or outreach to outpatient clinics, or something on the website, CBOT's website. I don't know. What are the possibilities of that?
There are possibilities. The first thing that comes to mind for me with that is that the board is really good at conducting outreach to its own licensees and educators. They already know. I think it seems like that this is something that they can do and that there's a certain framework that they operate within. The challenge is that it seems like the outreach is needed to other professions. And so it's something we can look into in how to best reach those other professions. But as it stands, our outreach is not particularly suited towards reaching people outside of our own licensed population. But it's something that we can definitely look into and see about how we could best reach out to those groups.
And is there an opportunity to put something on the website? Is that an option?
Yes, that is an option at the board's direction. If they would like me to do that, that's up to them. But
Clarifying question.
Yes.
So does that mean that the educational outreach that we do is not for consumers, but strictly for licensees? Is that what I'm hearing?
educating licensees about the laws and regulations does benefit is for the purpose of
Right,
benefiting consumers.
right. But as a tandem, something that's designed and written for practitioners and licensees, and something that is written for consumers of these services, that's not how our audience is only the licensees. Is that correct?
We have sorry, I think I see where you're getting at. When I was mentioning earlier that we're not great at reaching outside of our licensee population, that's half true. We are also good at reaching the consumer population of OT consumer services. So that is another group that we can do outreach to. We have a section on our website dedicated to resources for consumers. So we do have ways to conduct outreach to them as well.
Thank you so much. Thank you for clarifying.
Yes, the board is allowed to communicate with whomever they wish. It comes to when it's legally imposing or creating restrictions or expansions that have to be codified. But information certainly works for everybody.
Where do we want to go with this? So our options are just to call a day on this for now and just a good discussion, and OTAC takes it back and talks to their people. We could talk about getting something on the website, although to put something on the website, we need to come up with something to put on the website and a way to do that.
We could also you could also direct staff to come up with something to put on the website to bring to a future meeting. We don't have to decide what exactly goes on the website here today, but I would be happy to receive some direction to put something together.
And could it be an agenda item for when we reactivate the Education and Outreach Committee? Would that be
Yeah,
an
that's
appropriate
definitely
place as well?
within their scope.
Is that okay with you? Assign it to a committee and that we're looking at around July 1st on that, right? Is that what we're thinking? Or we just wanted to wait till after sunset?
Yeah, we
Yeah.
don't have like a hard date set, but we have not been very active in our committee. So we're getting ready to kind of kick those back into gear. I know we discussed a few committees last time at the last meeting, but I don't think we have any proposed dates for a new outreach and education committee meeting.
Okay. Well, what if we do this? How does this sound? What if when we reactivate the Education and Outreach Committee, which hopefully will be soon, now that sunset is over, is it entirely over? Or do you still have more work to do?
The worst is over.
The worst is over, yes. But I know there's still a little bit more to do. That's why I just didn't want to say like, okay, it's all over and now we're totally we have all this free time. No.
Staff has bandwidth for some committees, although I know we have a lot of carryover committee business from before the sunset started. For example, the practice committee has some meetings to take care of in regards to the advanced practices. And we just recently formed the ad hoc committee for AI and healthcare. So we do have a couple that are maybe in front of outreach and education for having some meetings due, but we can put them in the queue.
Okay, so how about and Ada, I so appreciate it because I know you are going to be on that committee, education and outreach. How about, and I appreciate you offering to take that on and not assigning it to the practice committee. So how about when we get that committee up and running, we put that on their agenda as one thing to talk about at their first meeting, coming up with some language around that to put on the website. How's that sound? Is that okay with everybody, Ada? Yeah, Matt, sound okay to you? Yeah, everybody here? Yeah.
Yes.
Okay.
Yes.
That's what we're going to do.
Thank you, everybody.
Are there any other, do I need to open this back up for public comment?
As Helen would say, it's always a good time.
Always time for
comment.
public comment.
Okay, let's do that, please.
Hi, this is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. If you're a call-in public member, you may press *3 to raise your hand. We'll give you a moment. See no comments, I return the floor back to you.
Okay, all right.
The Sammy Rafidi from OTAC. We are very grateful for the conversation and thank you. And we look forward to hearing more about the committee work and available with any supports or collaborations as needed or requested.
Thank you. Thank you. Okay, everyone, thank you. Moving on to agenda item 19, update on the board sunset review, discussion and possible action regarding Assembly Bill 2773. Mr. Porter.
Thank you. I'm going to kick it into high gear here a little bit here because we are on a bit of a time crunch for today. So with that in mind, I am not going to read all of the board responses to the various issues that were in the background paper for the board's sunset report. However, if any of the board members have any questions about the responses that were provided to the legislature, I'm happy to answer those.
While you're looking and thinking, I just want to say, again, the staff did a great job preparing for this. Austin in particular, I was there with him when we testified. He did a wonderful job also preparing me for that because I stepped in at the last minute for Beata, who was unable to be there. And I had a few days to prepare, and Austin worked overtime to get me ready for that. So I appreciate that. We did a great job as a team, if I do say so myself.
We did.
And yeah, it went well. So any questions for us?
One question regarding the discussion on page 7 about the suggestion of posting draft minutes. That's just an idea that's being floated in response to that question. Is that what I'm reading?
Yes, this is not anything that that's not something we've committed to doing. It's they're asked for suggestions, and they may take a look at the suggestions that we've provided and say, "Oh, that's a good one. Do that. We want you guys to do that." But at this point, they just asked for our suggestions, and that was what was suggested.
But we're waiting for them to come back with their response, interpretation, instruction from having read these items.
There's nothing stopping us from posting draft minutes if we decide that we want to do that on our own. They're not going to prohibit us from doing that. But generally, yeah, if they say, "Hey, here's an issue. What are some things you think you might be able to do about it?" Um, we can either say, "We will do this," or "Here's what we may do. Let us know how you'd like us to proceed." So this is more of a, "How would you like us to proceed?"
Got it. Thank you. And my other question is regarding the OTA workforce study. Is that ultimately then going to come back to a committee here on the board? Would that be the next step in doing something with that information?
That is number 7 on page 15,
Page
correct?
15.
It looks like, yeah, the response was indicating that this would be passed off to committee for further discussion.
Thank you.
So we'll work on that in the future. Absolutely. Okay. Yeah. Any other questions from board members, comments before we go to public comment? Okay, let's open it up to public comment online as well.
This is a moderator. If you would like to make a comment on agenda item 19, you may look for the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We will be displaying instructions and we could give you a moment. Seeing none, I return the floor back to you, Chair.
Okay. All right. I guess we're finished with this.
Okay. We have one last part of this
Can I
item.
ask a quick question?
Yeah.
Do we need to vote? Did the draft letter in support of AB 2773, did that go out, or do we need to vote to do that, or did
We're moving
I
on
don't
to
know
that
if we
right now, Matt. We're moving on to that right
Oh,
now.
gotcha.
Thank
Okay.
you. Thank you.
Yeah, so as Matt was saying, we have a draft letter in support of Assembly Bill 2773, which is the board sunset bill. This was drafted by staff. It's here for the board's consideration. If there are any questions, comments, or suggested edits, I'm happy to answer or implement those. But other than that, we would want to have a vote on sending this in support of our sunset bill.
Is anyone not in support of our sunset bill? Okay, good. How does the letter look to everyone? Beata
I think
seems-
it captures it well. Well done.
Do we have time to wait for her to?
Yeah, we have time to wait.
Okay.
You guys could vote to send this upon the board president's review, I assume would be.
Yeah.
Helen, would that be a problematic motion?
Restate.
Would it be problematic for a motion to say, if somebody were to move to send this letter to the legislature upon review of the board president?
We're just not sure she's had a chance to see it, but.
Oh yeah, no, you don't necessarily need a motion, but you can take one.
Okay.
Because as board president, that's part of her duties. But certainly, if the board would like to quote unquote codify that, absolutely.
Maybe we might want a motion on whether or not a motion and a vote on whether or not the board supports the bill. Maybe that just might be where we could draw the line, and then we can go with the letter from there.
Okay. Would it, would anyone like to make a motion in support of our sunset bill?
This is Vicky. I motion to go ahead and accept the motion and support of AB 2773.
Second.
And the second came from Aaron. Sorry. Okay. Is there any more discussion by board members? Nope. We're going to open it up for public comment. Any discussion on this?
This is the moderator. If you would like to make a comment on the motion, please click on the raise hand icon at the bottom of your WebEx screen. And if you're a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you, Chair.
Okay, thank you. Seeing no comments, let's call the vote, Ada.
Aaron Schwer,
Yes.
Vicky Santos,
Yes.
Matthew Greco,
Yes.
Louis Arabit,
Yes.
Ada Boone Hurl, yes. Christine Whitlisbach,
Yes.
Beata Marcos, absent.
Great, motion carries. Thank you. All right, moving on to agenda item 20, legislative update. Mr. Porter again.
Thank you. This is the first item in here in the materials is a chart of all the bills that the board has either taken a position on or is being asked to look at and consider whether they'd want to take a position today. A lot of these bills come from a legislative report from DCA, so they're very broad in terms of impacting either all of DCA or all of healing arts. Very few of them have anything to do specifically with the California Board of Occupational Therapy, other than our sunset bill, which was just discussed. I think maybe an efficient way to move through this would be that I will go through the chart here and identify any bills that the board has not considered, and then we can decide if they even would like to consider them in depth, and if they do, we'll look into either support or oppose positions or just watch. So the first bill that the board has not seen yet that was on the watch list from DCA is Assembly Bill 54. This is the Access to Safe Abortion Care Act. This is pretty far along in the, oh, you know what? This was ordered to the inactive file, was the most recent status from this. So if the board wants to discuss this further, if anybody has that opinion, we're happy to go into it further, but
I don't think there's a need if it's inactive right now.
Perfect. Moving on. There is an update to the status of AB 277, which has to deal with behavioral health centers facilities. The board last decided to take a watch position on this in February 2026. The text of the bill has not changed, nor has it been amended. There's just an update to the status. So this has moved on throughout the legislative process, just to keep the board aware. Assembly Bill 1558, the Uniform Emergency Volunteer Health Practitioners Act. This is something that the board has not seen before. It's currently in the appropriations suspense file as of May 6, 2026. So this could be moving on, although it seems like it probably has a big fiscal impact. So it might be in there for a little while. Is there
Austin,
any...
excuse me, I'm sorry. I can't find that. I went from the behavioral health to
It's on
in-home
page 3,
supportive
Ada.
services.
It's on page 3.
Oh, okay.
Do we have, unless you're missing a page, if you have page 3, it should be there, but I wouldn't say
Okay.
it's impossible that you might be missing page 3.
No, I do have page 3.
Okay.
We're not going to each item by item. You're doing the new ones first. My apologies. Is
Yeah,
that
sorry about
right?
that. I should
Okay.
have been more clear.
Okay. Got it. Okay. I'm with you. Thank you.
Hey, Austin, I think this bill is dead. I just looked it up and the bill is dead. It's in
Oh,
appropriations on suspense. So if it hasn't gotten out by last Thursday, it's done.
perfect.
Oh, thank you.
Well, not perfect, but
Thank you for the
yeah.
information. Thank you.
And there may be a couple other bills on the list that have moved a little bit forward since this was put together in the prior weeks. So happy to have any additional information on some of the bills like that. AB 1767. This has to deal with public members of boards and conflicts of interest. This is something that the board hasn't seen before either. Currently has been referred to the Committee on Business Professions and Economic Development in the Senate. So it's passed the Assembly. Currently existing law prohibits a public member of a board from being a current or past licensee of that board. This bill just places a more strict definition on what a close family member is. If that's something the board wants to look into, discuss further, we can take a look at the bill text.
I mean, to me, it's clear what it is. It just further defines what those relationships are, which I think is very important. I think the board has a stake in this because we want everything to be, for lack of a better word, on the
Fair.
up and up, fair, right? So I would I would speak to supporting this as a board, but I don't know how the rest of the board feels.
What bill number is this? I'm sorry.
This is AB 1767.
Are you looking up something about it, Matt? Are we waiting on you to? Okay.
Oh, I was just looking it up so I understood it.
So the definition that's provided by this change would be that for purposes of this section, close family member means a parent, step-parent, sibling, child by blood, adoption, or marriage, spouse, domestic partner, cohabitant, stepchild, immediate in-law, aunt, uncle, first cousin, grandparent, or grandchild. So it's just a clear definition of what a close family member is for the purposes of determining whether or not somebody can serve as a public member on a licensure board.
Okay. Understood. Thank you.
Let's open up for public comment, please.
Hi, this is the moderator. If you would like to make a comment on the legislative updates being discussed, please look for the raise hand icon at the bottom of your WebEx screen. And if you are a call-in public member, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments or raised hands. I return the floor back to you, Chair.
Okay. Any other board members want to talk about this? Is there a motion? It's okay if there's not a motion. We can just let this go, or we can move to support it or watch it, or
So it's really not changing the action. It's just providing a definition that provides clarity to something that's already moving through the system.
that's my understanding. It defines what a close family member is.
Definitions are always helpful in looking at details, so it would seem reasonable to support.
We would need a motion.
I motion that we support. This is Louis Arbit. I motion that we support. What bill is this again?
AB 1767.
Bill 18. Sorry. I lost my page. Here we go. Bill AB 250. Nope. 1767 by Berman.
Restate your motion, please.
I motion that we support AB 1767, where it says that the bill will define a close family member for purposes of that to mean parent, step-parent, sibling, child by blood, adoption or marriage, spouse, domestic partner, cohabitant, stepchild, immediate in-law, aunt, uncle, first cousin, grandparent, or grandchild.
Okay, there's a motion on the floor. Is there a second?
I'll
Second.
second.
Okay, Matt seconds. Is there any more discussion? Is there any more public comment or discussion?
Hi, if you would like to make a comment on this motion, please look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. See no comments. I return the floor back to you, Chair.
Okay. Ada, please call the vote.
Aaron Schwer,
Yes.
Vicky Santos,
Yes.
Matthew Greco,
Yes.
Louis Arabit,
Yes.
Ada Boone Hurl, yes. Christine Whitlisbach,
Yes.
Beata Marcos, absent.
Thank you. Motion carries.
Thank you. Moving on, we have Assembly Bill 1775. This has to deal with restoring benefits and status to veterans who were discharged from the armed services solely as a result of Executive Order number 14183.
Can I ask a quick, I'm sorry for interrupting, but
It's okay.
now that we we motioned to support the bill, shouldn't we have a second motion asking staff to draft a letter to the committee on behalf of of our board expressing our support for the letter or for the bill?
That's implied when we vote to support that.
Oh,
That they
okay.
will do that. Thank you,
Sorry.
though. No. Thank you.
Okay.
Thank you. Fair enough. Good question.
Yes, thank you. And then I'll bring it back for the board to look at before it actually gets sent out. 1775.
But hold on, Austin, wait, you can't bring it back to the board before they'll be voting on it in committee long before our next board meeting. So,
Oh, true.
and this is it's a 1-year bill, so it's not like it's going to come back next year. It needs, if you're going to draft a letter, then it's going to have to go out without us seeing it again.
You're absolutely right about that. So it is implied that you will write
think
the
that's implied.
letter, and it should just go out.
It's implied that I'll send it as well.
Okay. Are we okay with that, Helen?
Absolutely. Yeah, it's once the board takes a position, it is up to the EO to communicate that position to the legislative entities that are of importance. And of course, Beata as president, or if she's unavailable, you as vice president can always review it to aid the executive officer.
Gotcha. Okay. Thanks, Matt.
Thank
And
you.
Helen.
This bill would, 1775, essentially this would slightly expand the group of individuals that would qualify for expedited licensure processing. It does so by restoring benefits and status to veterans that were discharged as the result of this specific executive order. I don't think the impact of this would be too great as far as the board's ability to process those expedited applications. But we can take a look further if the board wants to discuss. Actually, this is going to be dead as well. It looks like this was also referred to the suspense file appropriations. So I think we can move on. AB 1979. This is another one that has to deal with artificial intelligence. So this used to including physicians' offices, to ensure that no clinical decision is based solely on the output of a clinical decision support system as defined. Yes. So this one I think is probably important for the board to take a look at. And we can go and look at the text of the bill. So following this table, there's text for all the bills. Flip forward to 1979.
Can I just ask, is OTAC following this, and have you guys talked about it and made a what
Yeah.
thing?
We've supported this one.
Okay.
Yeah.
From what I could tell, having not read it super in depth, it seems like it functions to serve the public. It prevents certain professionals from making, or not even making decisions, but acting on decisions that are more or less made by a generative AI software.
And this is something we talked about as a board at our last meeting that was important to us. So, anyone have any comments, Erin?
After reading through this prior to the meeting, I move to support this bill.
Second.
Okay. So we have a motion on the floor to support from Erin, second from Ada Boone Hurl. We're going to open it up for public comment.
Hi, this is the moderator. If you would like to make a comment on any of the legislations just being discussed, please look for the raise hand icon at the bottom of your WebEx screen. And if you are calling in by a call-in user, you may press *3 to raise your hand. We are displaying instructions and we'll give you a moment. See no comments, I turn the floor back to you, Chair.
Okay, thank you. So it doesn't look like there's any more comments from anyone off or on the board. So we have motion on the floor. So Ada, let's take the vote.
Aaron Schwer,
Yes.
Vicky Santos,
Yes.
Matthew Greco,
We can't hear you.
you're up. You're
Yes.
muted.
Thank you.
Thank you
Yes.
so much. Thank you. Louis Arabin,
Yes.
Ada Boone Hurl, yes. Christine Whitlisbach,
Yes.
Beata Marcos, absent.
All right, motion carries. Thank you.
Moving on to Assembly Bill 2140. This has to deal with claims against licensees. This makes it a failure of a licensee of various licensing boards, including the Board of Occupational Therapy under DCA, to report a settlement, judgment, or arbitration award over $3,000 of a claim or action for damages, or error or omission in practice. Let me find the consequences for this failure real quick. 30 days to report that to the agency that issued their license, punishable by a fine of at least $50, but no more than $500. So this would just establish in law a requirement for our licensees to report any arbitration award over $3,000.
We don't have to discuss this. This bill's dead.
Oh, perfect. Thank you.
Thank you,
It
Matt.
died. It died in committee.
Awesome.
There we go.
Awesome information. Thank you.
Team.
All right. Well, healthcare coverage, and I'll check the status on this one again before this one is in suspense at appropriations. Doesn't seem like that will be moving along. The suspense file again here for Well, this was our sunset bill, but it has since moved out of the suspense file. That's moved along. That's going to the assembly floor. We already discussed 2773. Which one? One moment. That's our sunset. So 2773 has moved out of the suspense file. That's gone on to the floor of the assembly, and fingers crossed should be moving on to the Senate after that. Then we move on to our Senate bills. SB 903. This again has to deal with artificial intelligence. This is in the suspense file since the 4th, so I think it looks like. Let me check if there's been any updated status. Or if Matt happens to know already, he's been pretty quick on them.
Hey, Matt, we can't hear you. Sorry.
AB 2551, I realize that's 2 bills ago, but the summary is the status information that's printed is not correct, or at least it's not consistent with what's on the official website. The official website, California Ledge Info, has that 2551 is on the assembly floor right now. It was not an appropriations bill. It's not appropriation. So that data for 2551 does not appear to be correct. At least, so, and it is AB 2551 healthcare coverage. It is an active bill in the floor process right now.
Okay, good to know. So then for that bill, the board would like to discuss it. It expands our reporting requirements for workforce data. This is something that the board already does automatically through Breeze for when we have applicants, and it reports that information. This would, what exactly would it change? Would also require mental health plans and insurers to collect that same information. Expands existing healing arts. Let me see if I can track down what exactly the expansion in requirements is. So it would include that the information collected or requested by boards would have to include whether a licensee or registrant is a contracted provider and the types of healthcare coverage under which contracted services are provided. And by provider, I believe that's referring to a healthcare provider. So
Is
this
that
is
even something that we can do?
So if this were to pass, we would have to ask for that information on the application. It would be added to the list of questions that we ask on an application. So there's like a survey that applicants fill out with some demographic information as well as, a practice setting and that kind of thing. It's optional for them to fill it out, but if they fill it out, it's mandatory that we report it.
And it's something we're
So-
already doing. I think we could just watch this one. But Matt, what were you going to say?
I read it really quickly to see what this was about. The legislature is concerned about what they consider to be a crisis in behavioral health and receiving that sort of treatment. And what they're focused on is they're trying to develop data that will show the lack of behavioral health treatment availability within managed plans. And the way they're going to do that is by requiring managed plans to report every time they have to contract out, or a patient has to go outside of the plan in order to receive that care. The idea being the more often they do that, the less access they actually have. That's kind of the way. There's a statement of intent that the legislature provided in terms of why they wanted to do this. And they briefly say that the healthcare service plans, they start by saying that access to behavioral health care is at a crisis point in California. And despite those millions of dollars being spent, there's not access by a huge swath of the population. And so that's what the concern is.
Got you. Thank you for that. Is OTAC following this? Looking at this?
I don't think so.
No? Okay.
I think we could just watch it.
I agree with Matt. Yeah. Everybody here agree with that? Okay. So we're going to open this up for public comment.
Hi, this is the moderator. If you would like to make a comment on this legislative update, please look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. See no comments. I turn the floor back to you, Chair.
Okay. No more comments. So we're just going to watch this. Okay. Thank you, Matt.
Yes, thank you. Okay, so now we're on to SB 903, dealing with artificial intelligence, I believe. That one was in suspense. Then SB 980. Last update I have on here was that the hearing was canceled at the request of the author. So I don't think we need to look into that one in much more depth. There is some proposed legislation that is, last update I have was that it was referred to the Assembly B&P committee. This has to deal with a retired license category. This bill will require.
Austin?
Yep.
Austin, sorry for interrupting you, but
No.
Padilla bill, SB 903 it was out of suspense. It got passed out of appropriations and is still an active bill right now. It is being read for the first time in the Assembly.
Okay. Then do we want to take a further look at the language from this? Probably would be a good idea. Okay.
Yes, we're going to do that because it has to do with artificial intelligence. This looks very similar to the other bill.
The only thing is, this is dealing with mental health, and I
Yes.
think that's kind of outside of our lane, isn't it?
Not really,
I mean,
because
it's
there's a lot of OTs that provide mental health services. I mean, yes, this looks like it's coming from the Board of Behavioral Sciences, which is another category, but we do provide mental health services. So I think it is something that we're interested in.
I agree because at the last meeting with Tammy Richmond, she gave some examples of when artificial intelligence was used in psychotherapy or
Right,
yeah.
you did.
Yeah, so I would support this bill.
What I'm hearing here is that if you're going to use AI, you need to disclose it. I'm all about disclosure and transparency.
Yes. Yeah, I would be okay and in support of the board supporting this bill. Let's open it up for public comment.
As the moderator, if you would like to make a comment on the Senate Bill 903, please look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you, Chair.
More discussion by, okay. Is there a motion?
I motion to support SB 903.
That's all you need to say. Thank you. Thank you. Is there a second?
Second.
Second from Ada?
Yes.
Okay, thank you. Any more discussion? We need to open for public comment one last time.
Hi, this is the moderator. If you would like to make a comment on the motion, please look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. See no comments, I return the floor back to you, Chair.
Okay, let's vote. Ada, please.
Karen Schwer,
Yes.
Vicky Santos,
Yes.
Matthew Greco, hear you, Matt?
Oh, yes. Yes.
Thank you.
Yes.
Okay.
Sorry.
Thank you. Louis Arabet,
Yes.
Ada Boone Hurl, yes. Christine Whitlisbach,
Yes.
Beata Marcos, absent.
Okay, motion carries. Thank you.
Moving on to SB 1391. This is a bill that would require any licensure board that offers a retired category of license to disclose that information on its internet website. Personally, I can attest that the board already discloses that information on its internet website, but if the board seems to think that other boards should be required to do that as well, then supporting this bill is for you.
I don't feel strongly that we have a stake in this, but if anyone feels differently, please say so. Okay, we'll open up for public comment.
This is the moderator. If you would like to make a comment on this agenda item, you may look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. Seeing none, I return the floor back to you, Chair.
Okay, we're done with this discussion on that.
We're just going to watch it.
We're just gonna we're just gonna watch it, yeah.
Yeah. Excellent. SB 1445. This is a omnibus bill for many healing arts boards and other licensure boards under the Department of Consumer Affairs. It may be beneficial for me to consult with DCA's Legislative Affairs Office before taking a position on this. They might have some input on that. But it's a very big bill. It affects a lot of licensure boards. But again, it's technical and clarifying in nature.
Do we have time?
I will defer to Matt on that one if he has anything.
This will be heard before our next board meeting as well.
Okay.
Okay.
But if we're not sure about
We're
it,
not sure,
then
we
should
should
do
just
nothing,
watch.
right? I mean, that's how I feel. I don't know how the rest of the board feels.
As far as I can tell, I don't see in the various code sections listed here 2570. So I don't think it affects us in particular. So probably best to let those that it affects make those decisions.
Is it on OTAX radar, Samia? Do you know if this one, SB 1445, is on OTAX radar?
It's
No.
not popping up in our document.
As
Okay.
far as I can tell, it doesn't have a direct impact on OT. It's just other licensure boards within consumer affairs.
I can't see Matt or Ada at all right this second.
Nope.
Do you guys have any feelings about this?
No.
I think, yeah, I don't. I think we should, I'm always concerned when it's omnibus bill that we don't really, know if it had us in it, I would be more comfortable taking a position to watch.
Mm-hmm. So you're saying you think, what are you saying exactly?
I think just watch it, just
Oh, okay,
not
okay.
take a position.
Gotcha. Yeah. Okay. And I think we're all kind of leaning that way. Okay. Okay. We'll just watch it then. Did we open for public comment on this?
I don't think we have.
Let's open for public comment on this.
As the moderator, if you would like to make a comment on this agenda item, please look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. See no comments, so I turn the floor back to you, Chair.
Okay. I think we've decided we'll just watch this one.
Great. Beyond that, in the table, there's just a list of bills that have been chaptered since the beginning of the legislative session, as well as some bills that have died, although clearly not all encompassing since some of them were still in the earlier part there. I don't think we need any in-depth discussion on those. That's just informational for board purposes. Too late to take a position either way.
Thank you. All right. Thank you very much on that. Matt, thank you for your extra input. Much appreciated. And Helen, as always. Moving on to agenda item 21, Executive Officer's Report.
Thank you. I can make this pretty quick. Fiscal month 9 revenue and expenditure reports. Currently, our revenue for the year is sitting at 2.8 million. Expenditures plus encumbrances sitting at about 2.4 million. So we're looking good in terms of our revenue to expenditure ratios for this current fiscal year. The fund condition statement that's included in the report assumes the fee increase that the board has voted for to take effect on July 1st, 2026. So it's possible that they may occur a little bit later, but even still, we would be okay. Budget office is projecting 8.8 months in reserve by fiscal year 29/30, which is a big improvement over what we were looking at before the fee increase. Brief personnel update. One of our staff services analysts in the administrative and licensing division applied for an opening that we had in the same division at the associate governmental program analyst position or level and succeeded in getting that. So we have filled our previous vacancy by creating another vacancy. We're still at one vacancy, but we're working on recruiting for that right now. Following the memo here, we have a more detailed version of the revenue report, as well as expenditures. That's the fund condition following that was discussed. And then moving beyond that, we get into our licensing data for the last quarter of the fiscal year. If there are any questions on this, I'm happy to answer, but it's steady as always. We are approving and receiving applications. Moving on, we have our enforcement data. This goes over total complaints open and received. This is down from what it's been in previous quarters, although we do see it ticking back up. So we're hoping to bring those numbers back up. A main contributing factor to this is that we've caught up on our address change violation cases. We're not having to open as many of those. We had a bit of a backlog, and now that those have tapered off, we're not opening quite as many cases throughout the year. You can see that we have closed 144. We still have about 700 pending. We have 19 cases pending at the Office of the Attorney General. We've had 8 final decisions become effective in the last quarter. Then we can see the breakdown of citations issued to occupational therapists. This is in the last quarter, I believe, 22 citations issued for a total of approximately $12,500 in fines. Then we move on to the same information for occupational therapy assistants. This is, sorry, I said 12 citations or 22 citations issued for OTs. That's incorrect. That's 33 citations issued. And then for OTAs, 13 citations issued, a total of about $3,700 in fines. We then have a more detailed breakdown of the cases that are pending at the AG's office. Some of those were discussed in closed session yesterday, so those have moved on in their status and will be taken off at the next meeting. And then we have a list of current probationers. Or sorry, we have a list of final decisions followed by our list of probationers. Are there any questions about any of the information in the report?
Okay, seeing none from the board at this time, we will open up for public comment.
Hey, this is the moderator. If you would like to make a comment on agenda item 21, please look for the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. I see no comments. I turn the floor back to you, Chair.
Thank you. Any board members come up with any questions, concerns for Austin? No? Okay. Okay. All right. All right. Suggestions for future agenda items. Anyone have anything that hasn't already come up that we've decided to talk about in the future? Okay. We can always call those in to Austin. Okay. Yeah. We're going to open it up for public. If you have any suggestions for future agenda items.
This is the moderator. If you would like to have a comment, please click on the raise hand icon at the bottom of your WebEx screen. We are displaying instructions and we'll give you a moment. See no comments. I turn the floor back to you, Chair.
All right. Do you want to talk about the next board meeting quickly? Just kind of where we're at on scheduling that and determining a location and all that.
Yeah, we're working on getting our website updated. This was just recently changed, but next board meeting is going to be September 3rd and 4th. This is going to be in the Bay Area. Exact location hasn't been determined yet, but we'll have more to come. But just know that the time and date will be September 3rd and 4th.
Great. Thank you. All right. That concludes our meeting. Thank you for bearing with me in the absence of our president, Beata. She should be back for our next board meeting. We are concluding this meeting at what time does that say? 1:02 p.m. Thank you, everyone.